morning, everyone. Thank you for joining us for today's online talk, which will be starting shortly. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Land Acquisition Appeals from the High Court to the Court of Appeal. My name is Vivien and I'm a Senior Associate with Phang and Associates. I will be your moderator for today's session. Before we start today's session, allow me to introduce the firm and what we do. Phang Associates is a mid-sized law firm that was founded in 1985 by our Datuk Ma Wing Kwai. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We're a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But since the implementation of the COVID-19 Movement Control Order, we have moved online in order to continue with our objectives of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, in-house counsel, and we have continued this practice until today. Today, we're expecting about 150 people who have registered with us. Please feel free to visit our website for more information on what each of our team does, our online products, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice, please feel free to contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now allow me to introduce our speakers today. Our first speaker is Ms. Denise Phang. She is a senior associate in our dispute resolution department. She holds a Bachelor of Laws from the University of London and was admitted to the High Court of Malaya in 2015. Denise's practice areas include corporate and commercial contracts, adjudication, arbitration, construction, and land-related disputes. Following Denise is our next speaker, our managing partner, Mr. Raymond Ma. Raymond graduated with a Bachelor of Laws from the University of Queensland and was admitted to the Malaysian Bar in 2005. Raymond's areas of practice include civil and corporate litigation, appeals and arbitration, and appears regularly at the High Court of Appeal and Federal Court. Our managing partner was recognized as one of Malaysia's top 100 lawyers by the Asia Business Law Journal in its 2021 A-list. Our talk today will cover the following points: overview of the land acquisition process, limitations on the right of appeal, appealing on questions of law, and recent Court of Appeal and Federal Court decisions. For today's session, our first speaker, Denise, will enlighten you on the overview of the land acquisition process and the limitations on the right of appeal, followed by our managing partner, Mr. Raymond Ma, who will enlighten you on the questions of law which are appealable with some of our most recent Court of Appeal and Federal Court decisions. We will then conclude with a Q&A session. If you have any questions, please type them in the Q&A section at the bottom of the screen. With that said, I will now pass the floor to our first speaker, Ms. Denise Phang. Over to you, Denise.
Thank you, Vivien. Thank you for the pleasant introduction. Good afternoon, ladies and gentlemen. Glad to see everybody and welcome again to our online talks today. Today we'll be speaking about land acquisition appeals from the High Court to the Court of Appeal. So if you could just let me have a moment to share my screen. Okay, there we go. So I will first be speaking on giving you an overview of the land acquisition process in Malaysia. So the land acquisition process is governed by the Land Acquisition Act 1960. And you can't simply acquire lands just because you want to. So Section 3 of the Land Acquisition Act provides that you can only acquire lands for three purposes. A, for any public purpose. B, for the benefit of economic development of the public by any person or corporation. Or C, for mining, residential, agricultural, or industrial purposes. So all landowners' rights are actually protected under Article 13 of the Federal Constitution. This would be your right to property, where sub 1 says no person shall be deprived of property save in accordance with law. So hence, that's why our Land Acquisition Act was enacted. So the Parliament has empowered the state authorities to acquire lands in a constitutional manner that is consistent with our federal constitution and your right to property. So sub 2 says, no law shall provide for the compulsory acquisition or use of property without adequate compensation. So in the Land Acquisition Act, we will also see some principles guiding parties on how to claim for compensation and how compensation is awarded. In the Land Acquisition Act, we will also see the entire process of the land acquisition being set out. So Form A, which is also, the Land Acquisition Act provides a few forms. Form A, B, C, D, E, right up to MNJK. So to start a land acquisition process, we start with Form A, which is a notice that the land is likely to be acquired. So this is usually the first point on where the public is notified of a likely acquisition. Then we move on to, there's Form B, where there's authority to enter land for survey. This is issued by the state to survey the land that is going to be acquired. Form C is a list of lands that is affected by the acquisition, and Form D is a declaration of intended acquisition. So depending on whether Form A and the date of Form A and Form D, the date of these two forms and the date of publication in the Gazette will actually determine the date of valuation of the land that is being acquired. There's also a yellow box under Form D, if you can take note in my slides. Form D is also where the starting point of calculating when you can file an action for judicial review to challenge any acquisition. So that is a separate High Court proceedings where you can challenge the acquiring authorities on the acquisition. I'll talk more on that later, but so let's continue with Form E. Form E is a notice of an inquiry. So when land is acquired, the state authorities represented by the land administrator will issue Form E to notify the landowners to come for an inquiry to determine the compensation to be awarded. Form F, which is usually served with Form E, also requires the landowner to produce evidence in writing. So this would usually include a valuation report, the land title, any tenancy agreements, or if let's say the land is charged to a bank, then a redemption statement will be required. In Form E, the land administrator will usually set a date for all interested persons to attend the inquiry to claim for the compensation. And during the inquiry, the land administrator will look through all the documents and confirm everybody's interest before awarding or not awarding any compensation. Award for compensation is issued in Form G by the land administrator. But usually during the inquiry, the land administrator would maybe orally pronounce his decision, and Form G being the written award is almost always actually sent later. Form H is a notice of the award, which is basically sort of like a cover letter for Form G. So a part of Form G will be annexed to Form H and will be sent to the landowners or persons interested, being the tenants or the chargee. So upon receiving Form H, the person interested would have three options: A, to accept the offer entirely, B, to accept the offer under protest, and C, to not accept the offer at all. So upon choosing option B and C, which is to accept under protest and to not accept the award, the person interested can actually object to the land administrator's award and refer the matter to the High Court. So this is done usually by way of Form N, which is an application that an objection be referred to the High Court. This is filed by the landowner or the person interested, and this results in a land reference at the High Court. Now, there are actually two separate proceedings at the High Court. One is, I mentioned briefly just now, is called the judicial review, which is basically a proceedings where the landowner gets to challenge the authority's decision to acquire. And this application must be filed from 3 months of Form D or Form E. So that's a very short window of 3 months for the landowner to institute any action. As for land reference, this is a separate type of High Court proceedings where the persons interested challenge the amount that was awarded, the amount of compensation that was awarded. So what they need to do is to submit Form N to the land administrator within 6 weeks of the inquiry. Note that it's 6 weeks from the inquiry where the land administrator pronounced his decision and not from the date of receipt of the Form G or Form H. So time starts to run when the land administrator orally pronounced its decision during the inquiry. I think some landowners do get this wrong and resulting in the late filing of their Form N. Okay, so since we are on the topic of appeals today, another difference between judicial review proceedings and land reference proceedings at the High Court is that the way of appeal, the rights of appeal are different. At the High Court judicial review proceedings, you can appeal to the Court of Appeal as of right. And if you are still dissatisfied with the Court of Appeal's decision, you would have to file what we call an application for leave, which is permission to appeal to the federal court. So you can't automatically file an appeal to the federal court. You have to first apply for leave. You need permission first. So that's judicial review proceedings. As for land reference proceedings, the High Court award, later on we'll touch on section 40D3 and sub 3 and section 49, which limits the right of appeal to the Court of Appeal. So for land reference proceedings, you can only appeal to the Court of Appeal on a point of question of law. And if this appeals relate to the quantum of compensation, then your appeal would be barred. And if, let's say, you are not satisfied with the Court of Appeal's decision, you do not need to apply for an application for leave. So you can straight away, just for land reference matters, you can appeal to the Federal Court after the Court of Appeal. So these are the differences between the two High Court proceedings. So now we'll take a closer look at the right of the sections governing the right to appeal to the Federal Court in land reference proceedings. This is governed under Section 49 of the Land Acquisition Act. So the Section 49 says that persons interested may appeal from a decision of the High Court to the Court of Appeal and to the Federal Court. However, there is a proviso in Section 49 which says that provided where the decision comprises of an award of compensation, there shall be no appeal therefrom. So Section 49 allows an appeal, but problem is it limits your right and bars compensation, appeals on decisions which comprises of an award of compensation. Now, this is the original wordings of Section 49, which was amended in 1997 to omit certain parts, but that is not that important. Then we have Section 40D, which was actually an addition to the Land Acquisition Act in 1997. So Section 40D introduced the role of assessors at the High Court land reference proceedings, and states that where they assess the amount shall be determined by the two assessors, and where the two assess, that's stated in sub 1. And if the two assessors different opinions on the amount of compensation, then the judge is restricted to concur with one of the assessors and award the amount decided by that assessor. So this is recorded in subsection 2. So these two subsections was actually struck out and declared as unconstitutional by the Federal Court in the case of Semenye Jaya. So therefore, Section 40D 1 and 2 is no longer operative, but Section 40D3 was actually preserved. This relates to a limitation on the right of appeal. So subsection 3 says any decision made under this section is final and there shall be no further appeal to a higher court on the matter. So at the face of it, Section 40D seems to restrict further appeals to a higher court on the matter. However, the courts have taken the approach to read Section 49 and Section 40D3 together. So hence, the courts have actually came through various court decisions, examined this provision, Section 49 and Section 40D3. So the first case was in 2011, Kalamas Sendirian Berhad against Pentadbil Batang Padang. So the federal court said this: I do not see anything ambiguous in Section 40D3 and Section 49 sub 1. In view of this, I am of the view that the appellant is precluded from appealing against the order of compensation issued by the learned trial judge. So the learned trial judge here would be the High Court judge. So Kalamas took in 2011, the High Court then and the Federal Court then took a very restrictive approach to Section 40D3 and Section 49(1). And this was also, the case of Kalamas was also affirmed or confirmed by the subsequent case of Sheikh Hussein Sheikh Junid. With the introduction of Section 40D, the amendment to the proviso of Section 49 sub 1, the intention of Parliament is very clear, i.e. to preclude any party from appealing against the order of compensation made by the High Court. So from 2011-2013 onwards, there was quite a restrictive approach to appeals to the Court of Appeal. However, this changed in 2017 when the case of Semenye Jaya was decided by the Federal Court. So the Federal Court said Section 49 sub 1 is not a complete bar on all appeals on questions of compensation, but limited to issues of fact on ground of quantum of compensation. So right of appeal against a High Court decision on questions of law. So in Semenye Jaya decided essentially that landowners can appeal to the Court of Appeal, but however, it must be on limited to questions of law and not quantum of compensation. Then we come to the next question, which is, what is a question of law? Now, this was not defined in Semenya Jaya, but it was defined, the federal court have given some guidance in subsequent cases. And at this point, I think I'll invite the next speaker, Mr. Raymond Ma, to speak on these issues.
Thank you very much, Denise, for covering all that ground. And thank you, Vivien, for the kind introduction earlier. Good afternoon, ladies and gentlemen. If you just give me a moment, I will take over the screen and then I'll move on with my part of the session. Okay. Denise and Vivien, does that look okay? All right, thank you.
Yes, Raymond.
Now, Denise has covered Section 49 earlier, together with the various cases that have applied it up to Semenya Jaya. But I thought I will also start with Section 49 just to recap some key points and maybe to add another point or two. So if you look at Section 49, that's really the cornerstone of any appeal from the High Court in a land reference matter, as well as the topic for today's discussion. So Section 49 clearly provides for an appeal or an avenue of appeal from the High Court to the Court of Appeal, and then from the Court of Appeal to the Federal Court. And as you can see in subsection 1, it says any person interested, including the land administrator, may appeal from a decision of the court, which refers to the High Court, to the Court of Appeal and to the Federal Court. So I'll just make a point there on these words, and to the Federal Court. The court has held that leave of the Federal Court is not required in an appeal from a decision of the Court of Appeal to the Federal Court under this provision. Now, if we study the cases, we will see rather inconsistent outcomes. There have been appeals that have gone up on land reference matters where leave was applied for and granted, and others where leave has not been applied for, but the appeal was nevertheless heard on the merits. And we have taken that approach, the latter approach in our experience, to appeal from the Court of Appeal to the Federal Court without applying or without the need for leave from the Federal Court. So Section 49(1) provides for this avenue of appeal, but there is, of course, this very important proviso, and that reads, provided that where the decision comprises an award of compensation, there shall be no appeal therefrom. So this proviso doesn't actually say, well, I suppose the question will be, you can appeal, but you can't appeal. So what can you appeal on? If the landowner cannot appeal against a decision which comprises an award of compensation, then what can the landowner actually appeal on? Now, this proviso doesn't actually say that you can only appeal on questions of law. And that's the phrase that we have been using in the last couple of years. It also doesn't say that you can only appeal on errors of law. But likewise, it doesn't say that appeals on questions of fact are prohibited, but it speaks instead in terms of compensation. And the Federal Court in the case of Nusantara has explained quite succinctly that an appeal can still be maintained on a question of law, as the proviso only bars appeals against issues of fact on the ground of quantum of compensation. So that's a mouthful, I'll say it again. The proviso only bars appeals against issues of fact on the ground of quantum of compensation. And I think if I can put it in another way, we understand this to be appeals on issues clearly relating to the application of valuation principles. Denise mentioned that there's also very important Section 40D, which at first blush appears to have been struck down by the Federal Court in Semenya Jaya. And the reason for that is quite unrelated to the topic today on appeals, but that also concerns an important question of law as to the role of judges and to the role of the assessors in the land acquisition and in the land reference process. So previously, what 40D1 and 40 and sub 2 said basically that the role of the judge was to hand over the decision-making power to the assessor sitting with him or her, and that where the assessors disagreed with one another, the judge was to select one or the other opinion rendered by the assessors, basically turning the judge into a rubber stamp. So the federal court in Semenyi Jaya struck that down. But the observation made was this, is that the unconstitutionality of Section 40D was only because of Section 1 and subsections 1 and subsection 2. And that the proviso limiting the appeal in subsection 3 was a succinct, separate and distinct issue, and that this finality clause in itself did not contribute to the invalidity of Section 40D. So that is the background to the appeal in terms of what is stated in the Land Acquisition Act. I'll just quickly move through the decision in Kalamas, which Denise covered earlier. I'll just say that Kalamas was a name we heard for many, many years because it was decided in 2011, and this was a case which was thrown at us by the respondent on every appeal to say that your appeal must fail from the outset because of Section 43 and Section 49(1). That side was in. And then, of course, the landmark case in Semenyi Jaya, which has made it very clear that Section 41 is not a complete bar on all appeals. All right, so this is where Denise left off. What is a question of law? To answer this question, we usually refer to the case we have of late referred to the two recent federal court cases of Amitabha Kuba as well as Nusantara Daya. And this is what has been said in summary. A question of law is an issue involving the interpretation of law, whether it be statutes or legal principles, and the application of the law to the facts of each individual case. Now, the federal court in Amitabha Kuba set out several examples, which I've summarized here in the second bullet points, and I'll just read through some of them to give you a case of what they might be. Questions of laws are questions about what the correct legal test is. It includes a mixed law and fact question about what the facts, or about whether the facts satisfy the legal test. The question of law is a question concerning the legal effect to be given to accept undisputed facts, or whether the decision maker has the necessary jurisdiction to determine a particular matter. Jurisdiction is always very clearly a question of law. It also includes errors of law committed by the decision maker, and this is it includes the application of the wrong law or the finding of fact in a complete absence of any evidence. So in these examples, we start to see a very close link between facts, evidence, as well as the law. So it is in fact a difficult question to answer. I'll just give you one more example from that case. The question of law can include the correct interpretation of a statutory provision and the inferring of a conclusion from the primary facts. Okay. So this is the case of Nusantara Daya, applying the federal court decision in Amitabha Guha, but narrowing the application and saying that the question of law, or what amounts to a question of law, should be interpreted strictly. And the federal court in Nusantara explained that the reason why a question of law, or what amounts to a question of law, should be interpreted strictly is because of the process afforded to the parties in the High Court. The parties were allowed to bring experts. There would have been an exchange of affidavits, cross-examinations, or due process from the hearing. And the parties have been afforded that process, and really what should come up on appeal is only strict questions of law and nothing relating to the application of valuation principles. I will spend the rest of my time on examples of questions of law, some of which are taken from decided cases and some from our own experience. First is the case of Semenyi Jaya. Now, there were 6 questions of law arising in this case and 2 constitutional questions. I've only listed out a couple from this case. But the answer, for example, to this question, whether there is a right of appeal to the Court of Appeal against a decision of the High Court consisting of a judge and two assessors involving compensation for land acquisition on a question of law in light of Section 40D3 and the proviso to Section 49, both of which we went through earlier. And in answering this, the federal court, of course, said this is a question of law, and they answered this in the positive to say, yes, there can be an appeal on a question of law. In this case, the Court of Appeal had dismissed the appeal, and the federal court reversed the decision by the Court of Appeal, allowing the appeal ultimately. This was another question by the landowner in the Manijaya case, whether the amended Section 40D is constitutionally valid in providing for a conclusive determination by the assessors as opposed to the judge as to the amount of compensation in face of Article 121 of the Federal Constitution that contemplates that judicial power of the courts should be exercised by a judge only. I touched on this earlier. Section 40D sub 1 and sub 2, it was argued, delegated judicial power, which rightly belonged to judges, to the assessors, depriving and at the same time depriving the judge of that power. So the federal court determined that this was a question of law that could be argued on appeal, and then answered it in the positive, saying that Section 40D was unconstitutional. The final example that I'm taking from the case of Sumanejaya, whether or not the safeguard of adequate compensation in Article 13 sub 2 of the Federal Constitution is met, where the land administrator refuses to take into account the development value or profit value of the land acquired, where the subject land at the time of acquisition is already being commercially developed for profit. So unlike the first two questions that I covered, this question comes much closer to the issue of compensation. It talks about whether a landowner is entitled to development value or profit value. But nevertheless, the federal court accepted this as a question of law and also answered it in the positive to say, yes, a owner is entitled to these losses. And this is where we get the principle of equivalence from this decision from the federal court in Sumanajaya's case. And I'll just touch on that because I think I already saw some questions regarding loss of profits, for example. And what was said in that case is that the principle of equivalence requires that a landowner be compensated for its, quote, true loss. And this had to include loss of its business. And that this claim for loss of business, true loss, fell under the heading of market value, which is stated as an item to be covered in paragraph 1 and 2A of the first schedule of the Land Acquisition Act as the basis for compensation. So what the federal court said was that the value of the land in its actual condition together with its profit value should be considered when determining the market value of that land. And in this case, loss of business should have been incorporated in the development value or the profit value, more so because, as is indicated in the question, the landowner had already begun commercially developing the land prior to the acquisition. So this has been a very useful principle for us in court. Now, I take another example of a question of law from Amitabha Guba's case. Here there were 8 questions of law raised. The federal court declined to answer some of them as the federal court thought that they related to compensation. So you can raise questions. You can call them questions of law in our submissions. If the court agrees that they're questions of law, the court will then answer them. It doesn't guarantee that they'll be answered in your favor as the landowner, but the court will at least answer them. If the court at the outset thinks that these questions are not questions of law, they won't be answered or considered at all. So it will be disregarded at the outset. But this is an example of one question which the court in Amitabha Guba's case did consider, and this was relating to the rate of interest or late payment charges. And the question is whether the provisions in the Land Acquisition Act, in particular, or rather the amending act, in particular, the amended rate of late payment charges at 5%, applied retrospectively. What happened by virtue of this amending act, the late payment charges rate was reduced from 8% to 5%. And the argument here was that, well, 8% should still apply in that case because that was the rate that applied at the time the land reference was started. And the federal court answered that question and answered it in favor of the landowner to say that the change in rate does not apply retrospectively because it is a substantive right which accrued or crystallized at the time the land reference was filed. Then we have a case that we handled in the estate of Tan Raymond, the estate of Tan Vivien, bought by the beneficiaries. And in this case, arguments were taken on the category of the lands. And the error of law that was argued here was that the lands the titles to which were issued prior to the Land Acquisition Act were in fact building lands under Section 53(3) of the National Land Code, as opposed to agricultural lands. And of course, having the lands valued at building lands would give a much higher value than agricultural lands. Now, what's interesting is this was a case that we had argued at the Court of Appeal before Semenya Jaya in 2017. So at that point in time, the phrase question of law was not in vogue, and we had argued it on the basis of an error of law. Nevertheless, still accepted because it was not an appeal on compensation per se, and the Court of Appeal agreed that the lands were in fact building lands and sent it back to the High Court for a rehearing on that basis. In this case, also the estate of Tan Vivien, but in respect of a subsequent acquisition, we argued that there was a breach of natural justice because there was inconsistency between the award given when the decision was announced in court and the decision indicated in the court's grounds of judgment, which was supplied to the party subsequently. And here, interestingly, even though the bottom figure remained unchanged, the adjustments given by the assessors were different. For example, I think in terms of adjustment, there was a minus 10% for size and a plus 10% for the development potential. That was what was announced in court, but when the grounds of judgments came, there was a negative 5% adjustment for size, negative 5% for terrain, and the same 10% for development potential. What we argued was that there was a change effectively in the grounds of the court and that parties had not been consulted or given an opportunity to submit on this change, and therefore that amounted to the breach of natural justice. That was allowed by the Court of Appeal, and the matter was sent back to the High Court for a rehearing. In this decision, KCSB, this is a matter that we handled in the High Court, in the JB High Court. Another very interesting matter. In this case, the land administrator gave a global award of some 350 million to all the persons interested, and that included the landowner, the tenants, the chargee. But the land administrator did not, as required by the Land Acquisition Act, did not apportion the amount to be given to each of them. So even though a global sum had been given, nobody knew how much they could take home. So that resulted in a host of land references being filed, 31 land references in total. Everyone went marching to the High Court. And at the High Court, the High Court decided that they would not proceed with the land reference matter, and struck the matter out. And the question that has arisen from that, and that's pending appeal at the Court of Appeal, is whether the court has the jurisdiction to inquire into Form H and Form N filed under the Act, objecting to the land administrator's award that does not state any apportionment for the compensation awarded by the land administrator to the parties named in Form G and Form H. Basically, the High Court there said that the decision by the land administrator was incomplete because it did not include the apportionment, and therefore there was no decision for them to review at the land reference. In this appeal from the High Court through the Court of Appeal, another matter that we handled, the argument here when it came to determining the market value of the scheduled land was whether a fire sale transaction is a suitable comparable. So it was argued for the landowner. We argued that a fire sale transaction cannot be used or should not be used as a comparable. And in order to prove that the comparables were a fire sale, affidavits were filed both by the landowner as well as the seller who had sold the land to our client, the landowner. And there it was stated that the price was agreed at a price below market value because the seller required cash urgently, and they accepted a lower price if the purchase price was paid in cash. So the Court of Appeal here agreed that this was a question of law, and that such a comparable was not a suitable comparable. In this matter, which is pending in the Court of Appeal, in fact, we had this hearing in October, and then the court has reserved its decision. Brings into question some very interesting questions, raises some very interesting questions. I am conscious that we are running out of time, so I'll just cover this case very quickly. What happened here is that at the land inquiry before the administrator, reports were exchanged, and the practice is that the land inquiry, parties do not exchange their valuation reports, meaning the landowner's report is given to the land administrator, and JPPH's report is also given to the land administrator, and JPPH doesn't know necessarily what's the landowner's valuation and vice versa. So a certain compensation was given, the landowner was unhappy, went to court, and of course in court documents are exchanged, and there the landowner discovered that the valuation given by JPPH was in fact much higher than what was given by its own valuer. Then in this rebuttal, the private valuer, the landowner's valuer, adopted JPPH's valuation, and an amendment was made, applied for to Phang and to include this additional claim of compensation for the market value of the land. So here we argued that there was a breach of natural justice because there wasn't an opportunity to exchange the valuation report at the land inquiry. But more importantly, that this breach of natural justice had caused prejudice because of this paragraph 4A of the first schedule, and that essentially says that a landowner cannot make a claim for more than what was claimed for at the hearing before the land administrator. And what happened at the High Court, at the land reference, the assessors took the opinion that the claim for a market value higher than what was claimed at the land inquiry ran foul of paragraph 4A, and therefore they declined to give an opinion on what the market value could otherwise have been. And so then we argued that that was also ultra vires of Section 40 of the Land Acquisition Act. I'm about done. I'll just run through very quickly what are some examples of questions which are not questions of law. We see this from the Nusantara Daya case, where I think some 10 questions of law were posed, all of which the court found were in fact questions relating to compensation. For example, there were arguments on misleading information in the valuation reports, or that the valuation reports were unreliable and that comparables were not appropriate. There was also arguments on potential development value that the court held did not amount to a question of law. Also, in this case of Amitabha Kuba, the question as to whether some of the appellants were properly disregarded did not amount to questions of law. Okay, that brings me to the end of my presentation. I think we're moving into questions now. Vivien, can you lead that section? Thank you.
Thank you, Raymond and Denise, for sharing with us. We will now move on to the Q&A session. The first question we have is, Is a High Court compensation award appealable? I believe we have answered that question just now, but maybe Raymond and Denise, you can share with us a short answer to this question we have here.
Well, the short.
Okay, Denise, you go ahead with your short answer. And I'll see if
Yes.
mine differs from yours.
The short answer is yes, but limited to only on questions of law. Is that your short answer, Raymond?
Well, my short answer was going to be along those lines, but since you answered a very proper answer, let me give you an alternative. Perhaps the answer will be yes if you have a good lawyer.
Thank you, Raymond and Denise. The next question we have is, can we claim for business loss?
Denise, would you like to take that one?
So it depends on what you mean by business loss. So in Semenjaya, for example, the case that we referred to just now, the court did allow profit value and business losses in that sense, because at the point of acquisition, there had already been S&P signed, and Semenjaya, there were purchases to the development already, and therefore that was a question. The federal court held that Semenjaya is entitled to claim for their profit value or business losses. So it depends on what stage of the development and how, I would say, whether your business losses is speculative or not. So you need to need to have evidence of your losses. So it depends on your case.
Perhaps I'll add to that. Denise, in our matter in Northern Green Ventures, what we have argued is that loss of development value or business loss in that sense should also be claimable. Even if a development order has not been obtained or applied for, because that's still that potential is still part of that land which is acquired. We'll see how that argument goes there. We're waiting for our decision on that argument.
Thank you. A relevant question to this, a follow-up question would be from Ms. Mani Usilapan. Her question is, if the loss of business are to be included into the market value of the land as per Semenjaya, then how would one separate or distinguish market value and the loss of business? Would it better to include loss of business as a matter to be considered as it has been done in other countries where there are specific provisions for it? Denise, would you like to take this question?
I think there's a little bit of a confusion about the Semenjaya case here. So Semenjaya held that development potential profit value is included in the market value, but if you're talking about actual tangible business losses, then it is not necessarily included in the market value. You can adduce evidence to prove your business losses. So there is a distinction between potential development and value and profit value, and also your business losses per se, that is pecuniary or can be calculated in that sense. Raymond, do you have anything to add to this question?
No, I think you've covered that. Vivien, you can stop sharing your screen, Vivien.
Okay, and the next question we have is, are the same judges involved with the decision for leave to appeal? Denise, Raymond, would you like to explain this?
Well, leave to appeal is not required in this appeal process from a decision of a high court in a land reference matter. So you go from the high court to the Court of Appeal, and then to the Court of Appeal to the federal court. At each stage, the court will make a determination on whether or not the questions posed or the issues raised are errors of law. So in that sense, it will be the same judges at the same hearing making this determination on whether or not they should proceed with the hearing on that basis and then make a decision on the questions raised. But in the sense of leave, if you were to go from the Court of Appeal to the federal court, in almost all other civil matters, then leave of the federal court is required before you get a hearing on the merits of the appeal, but not in this case because of Section 49(1) which we saw, which provides expressly for a right of appeal from the Court of Appeal to the Federal Court. And that the court has interpreted that right as being a right of appeal without having to obtain leave.
Thank you, Raymond. The next question we have from Ms. Mani is that there have been attempts of posing matters of valuation by valuers, especially adjustments made to sales, as questions of law on grounds that the judge at the High Court had erred in using the correct adjustments. A few cases have reached Court of Appeal and one succeeded, but Federal Court did not agree. Is it possible to raise these as questions of law? I believe this question goes to whether we can appeal against what the valuers have valued in terms of the adjustments made and the comparables used. I believe we have explained this just now in Nusantara Daya. Maybe Denise can elaborate a little bit further.
So for this question, if one succeeded but the Federal Court did not agree, so if so are you asking that, sorry, that the Federal Court, whether you can still raise these as questions of law? Or so if let's say the Federal Court has decided that it is not a question of law, it's a question of compensation, and then you can't appeal any further. So the Federal Court is the final appellate court in Malaysia. There is a possibility of filing an application for review of the Federal Court's decision, but that is depending on your case. That is actually a very rare procedure to a step to take, because the threshold for a review application is actually quite high. So the test is different. I think that's for another talk if we were to do it. But the short answer is, if the Federal Court did not agree with whether or not it's a question of quantum or it's a question of law, then your case ends there. Yeah, I think
Perhaps try to answer this question from a different perspective. If the question is, can matters relating to valuation by valuers still be posed as questions of law despite the various failed attempts, or perhaps the one successful attempt at the Court of Appeal, which was later overruled by the Federal Court? I think in practice, these decisions or unsuccessful attempts don't stop or won't stop or can't stop landowners from trying. And lawyers are very creative. They're constantly looking for ways in which we can push the boundaries of the law. As you can see, that was the outcome in Sembunyi Jaya, really breaking through what otherwise would have been a very restrictive provision. So I think attempts can still be made to advance these, but given the state of the law and the state of the recent decisions, I think it's fairly clear it will be an uphill battle to appeal on the application of valuation principles. I'll give you one example. If you're talking about whether something should be plus 10%, minus 20%, and you disagree because it conflicts with valuation principles, that might be an example of an appeal on valuation matters. Very difficult. But if you're talking about valuation principles where the two variables disagree with one another, should the court take the higher one, the lower one, somewhere in between? Those are questions I think which are still worth fighting for.
In fact, Raymond, if you can correct me if I'm wrong, that it's how it's based on the particulars, the facts of each case, and how the question of law is actually phrased. Am I correct to say that?
Yes, very much so, Vivien. I think how the question is phrased is very important, supported by the fact scenario. Some cases, just by virtue of the facts, give rise to very clear questions of law, as opposed to others. So we need to examine each case on their facts and circumstances.
Thank you, Raymond. Thank you, Denise. We have a specific question for Raymond here. Mr. Ma, what happens when the compulsory acquisition was made not for the purpose that it was intended for, and the first right of refusal was not given to the landowner or the vendor? When
we talk about purpose of acquisition, and if there is an argument taken that, well, this land should not have been acquired for a certain purpose, that really is an argument that can be taken up on judicial review. So if you get notice of the acquisition and you're not happy because, or for whatever reason, the solution to be pursued is an application for judicial review to challenge the decision by the government or the authorities to acquire your land. And that may or may not succeed. If you don't do that, if you don't go to court on a judicial review to challenge the decision to acquire, then this question of purpose becomes irrelevant, because if you go down the route, as we have been discussing today on a land reference, you are only talking about quantum of compensation.
Thank you, Raymond.
Thank you.
Next question we have is a procedural question. Does JPPH need to show the valuation report during land inquiries? Denise, can you share your experience with it?
Sure, Vivien. So this was the exact question that was asked by the court in our Northern Green Venture case. JPPH
They're losing
not
Denise
need
there.
to show the valuation.
Denise, we lost you there.
Hello, can you hear me?
Can you repeat? Yeah, we can hear you now.
So the short answer is no. JPPH does not need to show the valuation report during land inquiries because it's not provided for in the Land Acquisition Act. However, our argument in our Green Ventures case is that by principles of natural justice, all documents, information, evidence should be disclosed to parties, and parties should be given the opportunity to submit further or to retract, contradict, or even agree with any of the evidences that is presented during the land inquiry. So that was our argument at federal court and is currently pending before the Court of Appeal. So we'll maybe keep you informed on the decision. Mr. Tan Kok Yew, right? Yep. So please just
Perhaps I'll add to that, Denise. The observation by the High Court. So we ran this argument in the High Court, and the High Court judge in her grounds actually agreed with us that it would be ideal, it would be preferable if parties did exchange their valuation report before they land administrative with the natural justice. But she did not agree with us that it would render or rather that was a ground of a valid ground to increase the market value beyond what was claimed in the inquiry, on the basis that the Land Acquisition Act did not specifically say that the exchange of valuation reports was required, and therefore the failure to do so was not an error at the land inquiry.
Thank you for sharing with us, Denise and Raymond. The next question we have is, Section 3.1 of the Land Acquisition Act, what is a clear definition for any public purpose, as it is not clearly defined under the Act? Denise, would you like to take this?
Okay, so this question is actually discussed in another case of UAE United Alliance case. So in that case, the court held that it was alleged that the acquisition was for the construction of a mosque. So hence the land was acquired. However, the landowner managed to procure evidences to show that the acquirer had different intentions, and that it was the land was not actually acquired for the mosque or for any public purpose. So in that case, the Court of Appeal ruled in favor of the landowner, and the land acquisition was declared null and void. So which means that the land can no longer be acquired, and the landowner has successfully defended its land or retained its land. Yes, again, the Land Acquisition Act does not define public purpose, but it can be argued on a case-to-case basis.
Thank you, Denise. The next one we have is on loss of business, but this is for a tenant. So if it's a tenant who is a petrol station operator, has lost his business because of the acquisition, can he or she claim for that loss? Raymond, would you like to take this?
I think the short answer is yes. Denise, what would you like to add on that?
Can be lost, but the burden of proving that it has been extinguished is quite high actually, because tenants can actually change the place of business and continue its business. So to what extent it is extinguished, then it's a very high burden to be proven on the part of the tenant.
In fact, I think compensation has been given for relocation costs. Am I right, Denise?
Yes, so the Land Acquisition Act does provide that tenants can claim for relocation costs. So in order to claim for losses due to business extinguishment, then I think that boils down to the nature of the business itself.
Thank you, Denise.
Perhaps in the case where, in this case, the business could not have been relocated, perhaps.
Yes, for example, like in Semenyi Jaya, so it's a development, a commercial development on that land itself. So that's how in Semenyi Jaya, where the federal court said that there is an extinguishment of their business. So therefore they could claim for their business losses. So your business would have to be tied to the land itself, I guess, in that sense.
Thank you, Denise. Thank you, Raymond. The next question we have is, land is of agricultural nature, but agricultural category, I believe. But on the land, there's illegal factory being built and more than one structure on the agricultural land. Can the owner claim for illegal buildings, which most cases in Selangor, the land administrator have paid for? Denise, would you like to take this?
Legally speaking, if the building is illegal, then I have seen cases where the land administrator has declined to pay, and I've seen high court decisions upholding the land administrator's decision to not pay for illegal structures or buildings. For agricultural lands, yes, there can be one building on the land for as long as it ties to the nature of the agricultural. So, for example, it's let's say it's a farmer who is cultivating the agricultural land. The farmer has his house there. So, and if that land is acquired, yes, the farmer is entitled to compensation for his house because he lives there. But if it's illegal factories for other purposes, then most likely it's not claimable. So that's my answer to that question.
Next question we have is it a rule that a land administrator must only rely on JPPH valuation? Because usually the land administrator's reply is they are only allowed to increase 10% from the JPPH valuation. Denise, would you like to share your experience on this?
Okay, there's a reason behind this 10%. It's because in the land acquisition rules behind, which is seldom, it's actually quite often forgotten. The acquiring authorities is required to advance 110%. So before the acquisition exercise is executed, the acquiring authority, the person who wished to acquire the land, would have to pay the compensation to the land administrator first. So, and usually they are required to pay 110% of the JPPH valuation. So practically, when you come to the inquiry, the land administrator would only have 110% in his account. And so that is why sometimes it's an unwritten rule or it's a practice for the land administrator to just maybe increase the valuation by 10%.
Or up to 10%.
Yeah, up to 10%.
And the next one we have is, there are cases where a valuer or a particular valuation company is involved at a hearing at the land office for a specific project, but the same valuer is appointed as assessor for the same land reference at the High Court, not representing his previous client. Would this be a conflict of interest? Denise and Raymond, would you like to share with us?
Raymond, would you like to have a go?
Well, I wouldn't say definitively in this case whether there is a conflict of interest, but perhaps I'll say more generally. If a party is concerned that there is a conflict of interest, an application can be made to the court to recuse the assessor and to have another assessor appointed for that particular matter. And I think if there's anything along these lines, then it would be prudent to make that application.
Thank you, Raymond.
Vivien, I'm just going to roll back one question to the question earlier about the 10% and make an observation. Even though we've heard this being a concern at the inquiry before the land administrator, when it comes to court, this 10% is I think, very quickly forgotten. And we've seen many cases of the High Court increasing compensation to a lot more than 10%. So it's certainly something that doesn't weigh very heavily on the mind of the court.
Thank you.
Actually, to add to that answer as well, Raymond, the land administrator can also award more than 10%. The land administrator can award any amount,
Yes.
the market value for the land. However, the land administrator would have to ask the acquiring authorities to deposit further payments into its account. So there is a certain procedure that they have to undergo to increase the compensation. So I guess that's why most of the time the land administrators just stick to the 10%. So that's the situation now we are facing.
Okay. I'm conscious of the time, Vivien. Maybe you can just pick one or two more questions before we wrap up for today.
We have two last questions. First one is, must the valuation report be submitted for court hearing, i.e. land reference, and after receipt of the JBBH valuation report? Denise, would you like to explain the procedure for this?
A new valuations report. Well, depends on how you say it's new. So yes, you have to refile or resubmit a valuation report when you reach the High Court proceedings. And of course, after you receive JBPH's report at the High Court, you are required to file a rebuttal report, or at least the court will allow you the opportunity to file a rebuttal report. So in the rebuttal report, your valuer can examine the JBPH's valuation and reply or rebut to the valuation therein.
The question is whether you can file a different valuation report from that which was filed at the land inquiry. The answer is yes. There is no requirement that you have to file the same valuation report. But of course, if there's differences, that will have to be explained.
In fact, I think an application will need to be made to the court for leave to refile your report in some cases. Am I right, Raymond and Denise?
Yes, we've done that before for some, but it depends on the court. So if the court says if you would like to file a new valuation report, then the court will maybe direct you to file an application and hear your submissions on that grounds, on your grounds of why you want to file a new valuation report.
Okay, we'll take one last question. Apart from valuer's fee, can a claim be made for legal, town planning, and other fees resulting from the acquisition? I have a High Court giving award for these other professions for redrawing of the layout plan. Denise and Raymond, would you like to share with us?
By convention, courts rarely compensate such costs to the landowner. The reason being that cost is discretionary, and the court sometimes think that compensation would be sufficient to cover this cost of the professionals, and sometimes actually these professionals are not even required. So the courts usually do not award costs for other professionals. So, but parties, there are provisions under the Land Acquisition Act to claim for such costs, and we have been trying to claim for our clients, and some lucky clients get compensated for those costs and some don't. It's really on a case-to-case basis, and it depends on the discretion of the court.
We'll just take one final interesting question. For petrol station businesses such as Burak Oil is required by KPLB to build outskirts to provide a kind of service to them. But when it comes to land acquisition, because the land is agricultural, they are not compensated and not issued a Borang H. How should the landowner go about this? Raymond, would you like to take this?
So I take it that there is a petrol station, but the question here is whether or not that is a legal business, given that the land is agricultural. Well, what do you think, Denise?
I think in this case, the land, if the owner wants to claim for compensation, it first has, because it's the land, the tenant or the petrol station business is not recognized as a person interested in this acquisition itself. So this matter has to be taken up in the High Court, and Form N has to be filed in order to first establish a claim for compensation before the compensation can be assessed.
Thank you, Denise.
That's a great answer. Thank you, Denise. All right, Vivien.
Okay, and that's the end of our Q&A session for today. Thank you for your questions and sharing your insights with us, Raymond and Denise. That was very informative.
Our pleasure.
Before I conclude, I have 4 short announcements to make. First, we have in line a few upcoming talks, and we'll welcome you to join us if you're interested. On the 12th of November, our Senior Associate and Associate, Ms. Jasmine Wong and Mr. Eric To, will be giving a talk on citizenship for children born overseas. On the 24th of November, our Managing Partner will be giving another talk with our Associate, Mr. Sebastian Liu, on corporate mechanisms for financially distressed companies. And on the 1st of December, both our partners, Ms. Sarah Kambali and Mr. Gan Chong Chie, will be giving a talk on Islamic estate planning versus civil law estate planning. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. If you have any other questions, please fill it in and we'll get back to you as soon as we can, especially those questions which we didn't have time to answer earlier. We appreciate your comments so that we can continue to improve our talk series for you in the future. Thirdly, please do follow or like our social media accounts, as you can see before your screen now. And fourthly, if you would like to speak with our lawyers or us, we offer a complimentary 30-minute consultation over the phone or over video conference. Please fill in the form on our website. The link is also posted in the chat box. To our guests, thank you for joining us today. We hope you have found today's session very informative and useful. Thank you, everyone, and we hope to see you at our next talk. Stay safe and have a great day, everyone.
Thank you, Vivien. Thank you, Denise. And thank you, ladies and gentlemen. To those
Thank
of
you,
you who are
everybody.
celebrating tomorrow, happy Deepavali. Otherwise, happy holidays.
Thank you. Bye-bye.